welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Friends, welcome back. Jeff Roberts is back in the studio with us, and today we're going to talk about some of the things that people may do with a workers' compensation claim where they think they're helping their claim or their case, and in all actuality, as Jeff's going to explain, they may actually be harming it and causing problems. So, Jeff, welcome, guy.
Good afternoon, Jim. How are you today?
Buddy, I'm doing great. Great to see you again. And let's jump into this because I think, obviously, there's a lot on the line when somebody gets hurt at work and you're looking at, wow, I may be off work. I may not be able to come back. I may have some medical bills, all these other things. So people want to be careful and they want to do things to help. And a lot of times there's that need to want to get in there and mess with it. But you as the attorney are going to say, hey, let me handle this and I'll show you what to do, what not to do. But a lot of times they can make mistakes, and that's an issue. And one of the things that people neglect to do sometimes is actually report the injury or the accident, right?
That is true. That's one of the big threshold defenses that I see in a workers' compensation claim. When I use the term threshold defense, what I'm referring to, that is a defense that I have to overcome, or the injured worker has to overcome before they receive any benefits under the workers' compensation law. So if the defense wins on that issue, the case is dismissed. It's over with, exactly.
Regardless of the injuries.
Exactly. Even if I establish like on notice, if I establish the person that had a legitimate work-related injury that has caused them to even be completely 100% totally disabled, if they fail to give due and timely notice of that claim, they are not entitled to any workers' compensation benefits under Kentucky law. So that is something that individuals need to do whenever you are injured on the job. You need to report that injury as soon as practical after the work-related injury. And what I see a lot when I talk to people is, well, I didn't think it was that big of a deal, so I didn't tell my supervisor about it or go to HR about it because I thought, in a couple of days, it's just sore muscles. A couple of days I'd work through it and everything would be fine. And then I realized it was more significant than what it was. The best thing to do is if you're having pain or problems at work doing your activities, whether it's your back starts hurting while you're doing your activities, or if you just have what you think is a minor cut on your hand, tell somebody above you in the chain of command about that, because that minor cut, even though you may, in 90% of the time, 95% of the time, it's going to heal with no problems whatsoever. If it develops a bad infection, or if it's deeper than you think it is and you've cut tendons or nerves and it's more significant than just a little minor cut, then that can come back to haunt you if you have not told your supervisor about it later on, when you find out that it's actually much more significant than what you originally thought that it was going to be.
And so what happens if a company says, well, our policy is you have to notify us within 24 or 48 hours of the incident, or else, that's a violation of our company policy as it relates to the workers' comp. How do you deal with that?
The company policy has no bearing whatsoever on your workers' compensation claim. And I've had people come to me that I've talked to about their work injury, and they say, well, my employer said I didn't report it within 24 hours, therefore so I can't file it with workers' comp. I don't have a workers' comp claim anymore. That's not Kentucky law. Kentucky law, it does say as soon as practical after the injury, but there's no set deadline, and you can have some leeway and do have some leeway there. And if you're in a situation where you think it is sore muscles and then realize it hadn't gone away in 3 or 4 or 5 days, don't say, well, I didn't report it last week when it occurred, so there's no sense now. When you realize it's more significant, go ahead and report it at that point in time. It's best to report it when it first occurs, but if you've not given notice when you realize that it's more significant than just sore muscles or just a minor cut, report it at that point in time. And then if they deny the claim because you didn't give notice, then come see me and talk with me about it. And I'll see if there's a way that we can get around that notice requirement, or at least have what you the time you gave notice is being found as soon as practical. Because and there's some case law that specifically says and gives the injured worker some leeway in that regard, where they think that it's just a minor. You started doing a new job, and you had your shoulders were sore because you were doing stuff overhead, and you just thought it was sore muscles. Then find out you tore a rotator cuff in your shoulder, and the courts have said that is reasonable on their part not reporting it, because they didn't know they didn't know they truly were injured at that point. So we can get around it sometimes, but there's no guarantee. So best to go ahead and take care of getting that notice in.
You once had a case where the company was denying having received notice, but there was a pretty significant event that went on that you would have thought they probably would have taken note of.
Yes, and that's I oftentimes when I talk to people and about workers' comp or in people with work injuries, in others they will say something about fraud in the system, and I'm not going to. I've done this for 28 years, and I'm not going to sit here and tell you nobody's ever claimed to be injured on the job when they got injured somewhere else. That has occurred. But the fraud that I see, where I see fraud at much more, is on the employer side than what I see on the injured worker side. From that, but yes, going to what you were talking about, I did have it's been a few years back now. Gentleman worked at a large manufacturing facility. I won't mention the name, but it was a facility that they have overhead crane hoist. And somebody was moving that, pulling it by a chain, and it was going down. And my client had his back to it, didn't know it was coming. And the hoist part, the hook, which was fairly large, struck him in the back of the head and knocked him unconscious. And they actually, because of the nature of his injury and the severity of his injury, it was a facility that had a plant nursing facility. They came out. Ambulance come out. They called an air ambulance that landed in the employer's parking lot about an hour after the injury occurred.
So this is an actual medical helicopter landing in the parking lot.
In the parking lot, they had to actually have some employees move vehicles so that the helicopter could land in the parking lot, and life flighted my client to Nashville, to a hospital down there, and after his injury, after he recovered to the maximum that he was going to from the injury, and we were litigating the workers' compensation claim. One of the defenses that they raised up until shortly before the judge was to make a decision in the case was that my client had not given due and timely notice of the work injury, even though he was life flighted from the parking lot.
And you had a nice little back and forth with the judge there, right?
Well, it's funny thinking back on it, because it was just me, the judge, and the defense attorney in the room at what's called the benefit review conference, where we narrowed down the issues. And I had told the judge what my issues were in the case, and the defense attorney was listing his issues. And I had seen when they filed their initial paperwork that they had raised notice as an issue, and I just frankly assumed, because I knew my client had been life flighted, I just assumed the defense attorney hadn't talked with the employer or the insurance carrier when he filed the document, so he checked every box basically, which was pretty well checked on the initial form that they filed on what issues may or may not be presented in the claim. But then at this conference, 2 weeks before we had the final hearing, the defense attorney said, we've got an issue with notice in this claim too, Judge. And the judge kind of looked at me when he said that, and I said, Judge, I'd kind of like to know what their evidence is. My guy was life flighted from the parking lot an hour after the injury occurred. I think that's due and timely notice. From there, if they're going to say they didn't know the helicopter landed and then took off from their parking lot, that's fine. But I think they're going to have a hard time proving that. And the defense attorney looked at me, and he did not realize he'd been life lighted. He said he was life lighted from the parking lot, and I said, "Yeah, I can show you the bill for the life light if you want." And he looked at the judge and he said, "I think we can stipulate the notice now, Judge." So
Sometimes you just got to stand your ground.
and sometimes you need to make sure you've reviewed your file before you start raising what the issues are.
Yeah, that might be helpful. That might be helpful. So if I get injured, can I just tell one of the people on the line next to me, hey, can you go tell the supervisor that something happened? I got to go take care of this or whatever. Does that count as notice?
If the coworker does that, and telling your coworker that you were hurt does not count as notice. But if
it needs to be a supervisor, it needs to be somebody up.
It's got to be somebody above you in the chain of command. So if you have a line lead that's over you, telling the line lead is sufficient, or your supervisor, whatever they may call your immediate supervisor, you don't have to go up to the HR department to give notice. You don't have to go to the plant nurses station to give notice of a work injury. Just your immediate supervisor or above that level is who you have to tell. And if you cut your arm and you're going to go to the bathroom to wash it out and try to get the bleeding stopped, and you tell a coworker, go tell Supervisor John that I cut my arm. I'll be back to the line in a minute. And that coworker does go tell the supervisor that, then yes, that is sufficient notice.
Everything's fine.
You give and due and timely notice. If it occurs at the end of the day, you have a lifting incident and you go on home and the pain's greatly increasing, you decide to go to the emergency room, and your wife or husband or spouse calls into the employer and speaks to somebody in charge and says, "Yeah, we just want to let you know that he hurt his back, or he or she hurt his back lifting, and he's going to the emergency room." That's going to be considered timely notice. It does not necessarily have to be the injured worker that provides the notice. From that standpoint, but somebody needs to be telling the employer about the injury as soon as they can.
Yeah, because if you ask a coworker to go, tell somebody on your behalf and they forget or they get distracted, actually, technically, you never notified.
Exactly.
Yeah, that's the risk to that, right?
Yeah, that is the risk to it from that standpoint. But so if you do it yourself, it's been done,
right?
From that perspective, and if it's one where you are, you're going to seek medical treatment or you've sought medical treatment. Like if you told your supervisor, when I lifted that box earlier, it tweaked my back a little bit. And then that night or the next day you go to your family doctor or to the emergency room and you come back in, let them know that from that standpoint. And if they've not asked for a written report, because nearly every employer, once it gets to where you're seeking medical treatment, is going to want a written report, then you might want to bring that up because I've had these situations occur where when it was just a verbal to the supervisor, we have to have the supervisor come in and say, yes, they did tell me about this injury occurring, and so I knew the injury occurred. There was one against a local retailer or a large retailer where my client had slipped and fell, and they had claimed they did not get notice from that, and we took the supervisor, and the supervisor said, yes, I knew she fell. In fact, I'm the one who helped her up off the floor. So, but they never did document it in writing from that standpoint. So luckily the supervisor did remember that, and the supervisor was honest from that. And once the supervisor testified, that was no longer an issue in that case, but they had denied a lot of medical treatment, and we had to litigate it because the employer never went to the insurance company, or somebody never went to the supervisor and said, did you know about this fall? They just said, we don't have a written report, so it didn't occur.
Right.
And once we got involved, and then my client was able to get treatment, but it was a long way down the road before she was able to get the treatment that she needed because we had to get that issue straightened out.
You had to fight that first before you get beyond it.
Exactly.
And some other things that people might do is, obviously they say, okay, I'm gonna work through it, but if they end up seeking medical treatment again, come back and notify. But sometimes they, you might skip a doctor's appointment. Oh, I'm getting better. I'm going to. I'm not going to worry about it this time. That can also be harmful to the case, right?
It can. One of the defenses in a workers' compensation claim is that you failed to follow medical advice. And while that may not completely eliminate the claim like failure to give notice, it can severely limit the value of the claim. Now, it doesn't mean that you have to always undergo surgery. There are certain things that you have control over. But if you're supposed to be going to physical therapy and you miss therapy a lot, and the doctor says that's prolonged your healing process, they can stop paying benefits because you're not going to the medical treatment, the check while you're off work called temporary total disability. They can stop that when you do that. Or if if the doctor says, well, if they had done all the therapy that I had recommended, they would be able to lift a much greater amount and their impairment would not be as great as it is because they didn't do that, then the judge can say your benefits are going to be based on what you would have been if you had gone through that treatment. So that can be damaging to your claim from that perspective. So following your treating doctor's advice. But that does bring up another issue that I see frequently here in Western Kentucky, and that is that the employer tells the injured worker what treatment to go to. They will tell them, you go to this occupational medicine facility, or you go to this family doctor to get treatment, or we'll take you to Dr. So-and-so to get treatment. In Kentucky, the injured worker has a right to choose their medical provider. The insurance company, the employer, cannot dictate and say, you've got to go to Dr. A, B, and C to treat your injury. That you can pick who you wish to go to. Now, there's one caveat to that, and that is that under Kentucky law, an employer can have what's called a managed care plan. And under a managed care plan, the doctor has to be part of that managed care plan for you to treat with that doctor. They still can't say which doctor in that managed care plan that you have to go to, but if there's 5 family doctors in that managed care plan, but your family doctor is not one of those 5, they can say, well, you can't go to your family doctor. You got to choose one of these 5 that's in our plan to go to for your injury. And they can do that. They can't specify which one of those 5, but they can say, here's the list that you can choose from, and you get to pick from this list. But they have to be a true managed care plan before they can even make that limitation. Otherwise, you can go to whoever you wish to go to.
It's interesting because it seems like, wow, they're doing me a favor. They're actually going to give me some transportation to see this doctor. They're going to set that up for me. Wow, how awesome is that? These guys must really value me. But there's an ulterior motive.
As a general rule, yes, there's an ulterior motive. When you have a medical professional that the plant nurse is always there at the doctor's visits. The plant nurse is bringing him or her several injured patients to treat and has a relationship with them, then that doctor may not be looking out as much for the patient as another doctor would, for instance.
It's a business, and that is a revenue stream, and they want to protect that revenue stream.
Yes, to a large extent. Now, some,
not all, but
not all do that. But and also one of the issues is that you see a lot of times is every injury documented in that first medical treatment. I fight cases all the time where the person has a shoulder and a neck injury. Well, they go to the doctor, and the doctor documents all the problems with the shoulder and doesn't mention the neck until 3 months down the road or whatever. And then they come in and say, well, the neck wasn't ever part of this claim. You only mentioned shoulder at that first office visit. And I see that much more frequently when the first doctor is somebody the insurance company or the employer sent the person to than I do when they go to their family doctor, because and I'm not saying why that is. I just say that's where I see it more frequently in that setting. from that standpoint. And a lot of times where the key factor comes in is physical therapy records, because if they send them to physical therapy records and a week later they're at therapy and they say, yeah, my shoulders, they sent me here for shoulder, and then I'm having some neck issues and pain up in there, and then we can document, yeah, they had these problems early on, and for some reason the initial doctor didn't document it, but it was documented within a week, and that usually makes it takes care of any issue, but
not that far of a leap.
Correct.
Yeah, that makes sense. Now, and then you talked about treatment and rehabilitation and things like that. That also comes down to medication issues. A lot of times people will think, well, okay, I've got this prescription, but it's kind of expensive. I think maybe instead of worrying about the co-pays and stuff like that, maybe I don't need all of this medicine, so I'll skimp over here, or maybe I won't fill that prescription, thinking I'm actually saving some money, but actually that also can have a negative impact on the case at the end of the day.
Certainly can, and you see that as a reason why people don't seek medical treatment right off the bat, because they don't want another bill to have to pay. We all have enough bills. We don't need any more. In Kentucky, for a work-related injury, if you're getting medical treatment for a work-related injury, then as long as the treatment is reasonable and is for the work injury, there are no co-pays, there are no deductibles. The injured worker is not out of pocket any money for that treatment. Now, the carrier has to have time to set the claim up. So there can be situations where you are out a co-pay right off the bat. So, if you're working at a plant and you lift a heavy box and have back pain and go to the emergency room, the emergency room bill is going to be processed and sent, and workers' comp carrier is going to pick that up in all likelihood, because they're not going to get the bill till 2 or 3 weeks later after the claim is set up with the insurance company. But if the ER doctor writes you a muscle relaxer and you go from the ER to your local pharmacy and go in to fill that prescription, the workers' compensation carrier probably has no idea about your work injury at that point in time. You're only a few hours out from the injury maybe, and so they don't have the claim set up. So that first prescription, you may have to pay your copay there and then get reimbursed at a later time from that. And I see that frequently occur, but don't hesitate on doing that. Once that claim gets set up, it's just a matter of sending the receipt in and the prescription in and the receipt on the proper form, and you'll get reimbursed. Shouldn't be any problem whatsoever.
Right. But again, skipping a medication or failing to take a medication shows a deviation from the treatment protocols that the physician has prescribed, right? And that really creates a hole for you, and you've got to kind of argue around that sometimes.
It certainly can create a problem from that standpoint. And the other side to that is, everybody wants to get better from an injury. And, the muscle relaxer medications and things of that nature that the doctors prescribe, they're prescribing that to help you, either help with the pain that you're experiencing right then, but also to help you get better from the injury. If you have even if it is muscle spasms and muscle strains versus a herniated disc, the muscle relaxer will help those muscles to relax and to help you to recover from that strain much quicker than if the pain just continues and the muscles stay tightened up for a longer period of time.
Right, and that can have other problems down the road if you're not really careful.
Correct.
So that makes a lot of sense.
And let me make a caveat there that I'm relaying what doctors have told me. I'm not giving anybody medical advice.
Right. What are you saying? If you wanted an easy job, you would have gone to med school?
Exactly. I did not sleep at a Holiday Inn Express last night, so I'm not, and I did not play a doctor on TV, so I'm not giving anybody medical advice.
Not going to do it on this podcast either.
That's right.
That makes a lot of sense. Jeff, there are a lot of other situations where, again, somebody tries to take action to help the case, but it's best if you have a question, wouldn't you prefer that they actually call you and let you discuss it with them before they change something or do something differently? Isn't that probably the best course of advice?
It is. Whenever you have a claim going forward like that, if you have questions, or before you make a drastic action, or if you're going to change doctors and things of that nature, talk with an attorney ahead of time before you do that. And I've seen it, unfortunately, where the person comes in, and they've let the insurance company dictate who they see, and then they're not happy with who they're seeing. And in Kentucky goes by a gatekeeper process to some extent, which means that you can have a gatekeeper doctor or medical professional. It can be a nurse practitioner that kind of oversees your care, and they can refer you to specialists or refer you to other individuals. And you can change that gatekeeper one time without the insurance company's approval. And then after that, they have to approve before you can change that gatekeeper again. And my advice is to my clients who've not designated a gatekeeper is if the family doctor, your personal family doctor who's been your family doctor for a while, is agreeable to being the gatekeeper, use your family doctor as the gatekeeper physician. But I'll have times where the company will send the person to their doctor, the company doctor to treat with initially, have them designate that company doctor as the gatekeeper doctor, and then the gatekeeper refer them to a specialist who is also a company doctor. And then the insurance company, even though there is no need to change your gatekeeper physician in that setting, a lot of times the insurance company will say, we need to designate the specialist as the gatekeeper doctor now, and have the person designate the specialist as the second gatekeeper, not realizing that now they cannot change without approval from the insurance company.
They played both of those cards now.
Yes, and then if you're not happy with that specialist, trying to get one medical specialist to refer you to a different medical specialist that is the exact same specialty is very difficult.
I would think so.
From that standpoint. So then you can and then you can make your attorney's job a lot harder trying to get you to a different doctor that's a doctor that you want to treat with from that standpoint, or you're stuck treating with a doctor that you don't really have a lot of confidence in, and you need to have confidence in your doctor and your attorney.
Especially as more severe the injuries happen to be. Yeah, that confidence is everything.
Correct.
A lot of times it is. Jeff, as we were planning for this show, you had also wanted to bring up something about some safety issues and safety violations, because that's kind of related, but it's a little off topic for this, but it's closely related. So let's open that up a little bit.
It's kind of, it goes along to some extent with the notice. In Kentucky, if you're injured on the job and that injury is because of the employer or a coworker violating a safety statute or a safety policy of the employer, then your benefits can actually be increased by 30% for that safety violation. And so if your employer puts you on a table saw that they've taken the guard off of, and you cut yourself, that they've committed a safety violation in that setting, and so your benefits can be increased and should be increased in that situation. So if you, when you're giving notice, if there has been a safety violation, you had lockout tagout in place on your machine, and somebody unlocked it and turned the power back onto that machine, and it caused your injury, then document that in your notice. When you provide written notice to them about that, document or that safety violation occurred from that standpoint. Now the same though applies the other direction. If you violate a safety policy yourself and that causes your injury, then that can reduce what you're entitled to under the workers' comp law by 15%. It's not the same amount. It's only 15% on the reduction of the benefits from that standpoint. So you should do this anyway, but make sure you follow all the safety standards, all the safety guidelines that you're supposed to be following. Hopefully that will prevent you from getting injured in the first place, but it'll stop you from having, because right now when you're injured on the job in Kentucky, your benefits for lost wages while you're off work under doctor's orders is 66 2/3% of your average weekly wage, subject to a cap. So the higher the wages, actually, it can be less than 66 2/3%. So if you turn around and take another 15% off of that, paying your bills can be very difficult. So,
Absolutely.
So make sure that
Absolutely.
you comply with all the safety rules that your employer has in place. And if they're asking you to do a job that, they've disabled the safety functions on that job, bring that up before you do it and try to get the machine fixed before
Right.
you operate it.
It's not worth it. It's not worth it at the end of the day to suffer a severe injury.
Yes.
Because
Or
somebody
death.
was, or death, because somebody was taking a shortcut like that. That's unfortunately it happens.
Yeah, unfortunately, I've seen it.
Yeah. Jeff, I really appreciate it. This was some really solid advice. And in the show notes, I'll make sure that we summarize these very succinctly so people can look, these are some important steps to remember if you're involved in a workers' comp claim here in Kentucky, because again, you may have good intentions, but at the end of the day, the net effect could be you actually are harming your claim or your case. And for that reason, pay close attention to this. If you want to go back and share this with friends, I would absolutely encourage you to do so. Jeff, I appreciate your time today. Thanks very much.
Thank you. Appreciate it.
We'll talk to you next time. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.